respected leaders, minds have met. There's an agreement. The two leaders have agreed. So shall we proceed from there, Speaker? Please. There's an agreement.
Is that the agreement by the two leaders?
Mr. Speaker, from the very moment when my colleague, the minority leader, indicated his desire to bring a private member's motion, I have not hidden my opposition to it. So, Mr. Speaker, I think we're in your hands. And that was what I indicated to the second Deputy Speaker, that we will be in your hands.
Yes, honourable members, item number 16 at page 6 of today's order paper. Private members' motion. Yes, Honourable Majority Leader.
Mr. Speaker, in private, I had indicated and intimated to the minority leader that I am opposed to the motion advertised. Because the motion, Mr. Speaker, is to the effect that this House, this Honourable House, considers the directive by the Chief of Staff, Honourable Julius Debra, in a letter dated 10 February 2025, with reference...
Honourable Majority Leader, you should... Very well.
It is already the property of the House because it has been advertised.
Yes.
It has been advertised. Listen, it has been advertised. It has been advertised, and I want to object to it being moved in the first place. Not to oppose the motion after it has been moved. To object to it being moved. The objection is to it being moved.
Very
and
well.
That was the understanding between us.
Very well. If
I should arrest it,
yes,
and then the Speaker will rule.
Very well.
And then the next step will take place.
Very well.
That was the understanding in private. Well. Yes. So I said that I was going to attempt to arrest it.
Yes. So, Majority Leader, let me hear the Minority Leader briefly. Then I'll come back to you so that you can raise your objection.
Mr. Speaker, I always say that I want the jurisprudence of the House to guide me. And if in this night Parliament we are setting certain precedents, that precedence would help all of us, and Hansard would be the witness. Mr. Speaker, speakers have ruled on this very important matter, that a preliminary objection to a motion can only be triggered after the motion has been moved and seconded. However, Mr. Speaker, if the new practice in this ninth Parliament is that a preliminary objection, a preliminary legal objection, or any form of objection to a motion must be raised before the motion is moved, it's fine. Because I remember in the 7th Parliament, in the matter of Kennedy Japan, when it came to the contempt matter, I stood on the majority side in the 7th Parliament at the back bench and raised a preliminary objection to arrest the motion. The ruling of Professor Okwe was that no, the motion must first be moved, seconded, and then the motion will be properly before the House. In the matter of Kenoforiata, Honorable Ayerega, Honorable Ayerega, wait. In the matter of Kenoforiata, then as Deputy Majority Leader, I again rose on preliminary objection to the motion. Again, Mr. Speaker, relying on precedents, said that no, the motion would have to be moved, seconded. It is only upon that would be seized with the matter. Then my preliminary objection on the matter could be raised. And if it is upheld, then there will be no debate on it. Mr. Speaker, Mr. Ayerega himself, then in the minority, was part of those who argue strongly on this matter. However, Mr. Speaker, all we're doing is for posterity. I am fine if he would want to raise his preliminary objection for you to rule upon it, and if whichever way it goes, we'll know what to do. If the new practice is that a preliminary objection must be raised before a motion is considered, so that if the matter is considered, the application fails, you can now move. If it succeeds, the whole thing is arrested. Don't let us also forget, Mr. Speaker, in the Doe Ajaho case, Honorable Dominic Nitiwu, in the Merchant Bank's case, again, when he moved a motion, there was a preliminary objection to it. Right Honorable Ajaho allowed the motion to be moved, seconded. Then after that, the preliminary objection was raised from the majority side, and he ruled on it and sustained the objection. Mr. Speaker, there are 3 precedents from 3 different speakers on this matter. You are in the chair now as the presiding officer. If you want to vary the precedents, this would be the new precedents, and I'll be guided. I don't have a problem. Thank you, sir.
Honourable Majority Leader.
Mr. Speaker, the terms of the motion are captured in the order paper. So we know what the motion is. We know what the motion is. It's not as if we don't know what the motion is. So when a motion is advertised and you think that that motion, if moved, would offend a provision of the standing orders, you should be able to arrest it before it is moved. The reason is that in moving the motion, the mover will already make comments or even argue in support of the motion. So whatever you are seeking to arrest, you will lose the opportunity to arrest it, because the motion is moved and the terms in which it is going to be moved will unearth the issues that you think offend the provisions of the standing orders. So the proper thing to do is that once the content of the motion is known and the motion has been advertised and everybody can read it, if you think it should not be moved, it is before it is moved. When you give indications that the motion is about to be moved, that's when you arrest it. You seek to stop it from being moved so that it is not moved. If you rule that the objection is not well founded, then he can go ahead and move the motion, argue, and then we'll all debate the provisions of the motion. I think that's the proper practice.
Honourable members, I think we are talking about 2 separate things here. In the Merchant Bank case, I think the objection was to the effect that such a motion should not be debated. Therefore, the motion was moved, and when it's time for it to be debated, then the preliminary objection was taken. That has got to do with truncating the debate of the motion. But in this case, he is of the view that the motion ought not to have been moved at all. So that is the distinction that I am getting. Yes, Honorable Okonkwo.
Mr. Speaker, just to help the conversation, akin to what will be happening in the courts, if this proposal is accepted, it will mean that when a writ is issued, even before the motion is actually moved by a lawyer in court, another lawyer can go without the matter having been moved to seek to arrest it. That would not be proper. It is important that though it has been advertised on the order paper, it be moved and seconded, and then whatever objection there is raised, and then it can be dealt with by the Speaker. Thank you, Mr. Speaker.
Honorable Kojo Oponkruma, as a matter of fact, if it were to be in courtroom and you don't want the motion to be heard, you raise a preliminary objection when the mover of the motion is on his feet to move the motion. After the motion is moved, you will be given the opportunity to respond to the motion. In that case, your response cannot be a preliminary objection to the application. That is why I'm saying that I have the distinction that one is to the effect that a debate on the motion should be truncated. The other one is to the effect that the motion ought not to have been moved at all. And I think that is what Honorable Majority Leader Mahama Ayariga is saying. So may we hear your preliminary objection.
Mr. Speaker, the motion is to the effect that this House considers the directive by the Chief of Staff, Honorable Julius Debra, in a letter dated 10th February 2025 with reference SCR/DA 85/85/01/A, and refers the matter to a committee of Parliament to inquire and report to the House, as the directive is inconsistent with good governance practices and has consequences on the rights of citizens as provided for under Chapter 5 and 6 of the 1992 Constitution. So, Speaker, these are the terms of the motion that he seeks to move. My objection to this motion being moved is to the effect that, one, the matters contained in the motion are matters that are sub judice because there is an application before the Supreme Court by one Henry Nana Boachi, who has sued the Attorney General, and he is seeking some remedies in relation to this same matter. So the matter is in court. And the citation of the case is Henry Nana Boachi versus Attorney General and Minister for Justice, J1/12/2025. And he is seeking some reliefs, a declaration to the effect that the directive is unconstitutional, some orders to the effect that, the directive should not be enforced, and even some compensation that he is claiming should be given. So those are the issues that are the subject of litigation in the Supreme Court. Now, once this matter is in the Supreme Court, he is saying that this House should also refer the matter to the Human Rights Committee of the House for a determination that the letter has the consequence of violating the rights of citizens. So my position is that, look, the matter is already in the Supreme Court. Why would you raise the matter in this House and also seek that this House refers it to a committee, and the committee will be engaged in a parallel exercise of determining whether or not the consequence of the letter is to violate the rights of citizens? The matter is already before the Supreme Court. And I also argued that what you are seeking to do, in effect, is to ask this House to engage in a judicial function. A judicial function, a determination that the letter violates the rights of citizens. So that's a judicial function you are asking this House to engage in. The nature of the work of committees is to ascertain facts. Ascertain facts. That's mostly what committees do. Not to make a determination of a violation of rights or not. The determination of the violation of rights is a function of the judiciary. So my objection to this motion being moved is on two counts. One, that is a matter that is already before the courts. And I don't see how we are going to move this motion and debate it without violating Order 1231 of our standing orders. And Order 1231 says that a member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way as may, in the opinion of the person presiding, prejudice the interests of parties to the action. Mr. Speaker, my contention is that if this motion is moved and we are going to debate this motion, there's no way that that debate will not prejudice the outcome or the interests of parties in the action. There's no way. Because the very issue that the court is supposed to determine is the issue that we are going to debate and refer to the Human Rights Committee. Because we cannot just say, oh, we are referring to the Human Rights Committee. We have to debate the merits. We have to debate the merits. And in debating the merits, we will end up offending Order 123 of our standing orders. But the standing orders say that it is up to you as the Speaker, if in your opinion the debate will prejudice the interests of parties in the litigation, then we cannot engage in that debate. So, Mr. Speaker, I think that given the fact that the matter is already before the Supreme Court, that the parties in the court have interest, this is a matter that, is well known. I don't see why this Parliament should also refer to this Human Rights Committee.
Yarega, take a look at Standing Order 123 again.
Yes, Mr. Speaker. What about it?
Yeah, you can read it together.
So a member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way as may, in the opinion of the person presiding, prejudice the interests of parties to the action.
So at what point is the matter debated?
Mr. Speaker, that is the point.
After the motion is moved.
Mr. Speaker, that is the point I'm making. The point I'm making is that there are two grounds on which I'm raising the objection. The first ground is that under our Constitution, we must not interfere with the work of the judiciary. Under our Constitution. So, if the judiciary is already seized with a matter, Parliament should not also take up that same matter and refer it to its Human Rights Committee. You will be interfering with the work of the judiciary. Under the Constitution, we owe the judiciary a duty not to interfere with their work. And my argument is that we taking up the matter and referring it to our Human Rights Committee to also inquire into will be interfering in the work of the judiciary. That's my first argument. And I'm saying that my second leg is that if we are to move the motion, it will be difficult for us to move the motion without making statements. Whether we are moving it, we are debating it, whichever way, we will end up prejudicing the interests of parties in the matter. So, if you combine the two grounds, my contention, Right Honorable Speaker, is that the motion should not even be moved. Because I know how he's going to move the motion. In moving the motion, he's going to marshal all the arguments. That is where the problem is. He's not just going to get up and stand on his feet and say, I move in terms of the motion paper, and then that is not what he's going to say. He's going to move the motion and marshal every argument. At what point do we arrest the statements that will prejudice the outcome of the interests of parties in the litigation that is at the Supreme Court? So it is better that we argue the grounds for the motion not being moved at all, for you to rule at that stage, then we move on. Otherwise, if we say let's move, the person moving, the person seconding, the arguments that they will put forward in moving and in seconding, all those will end up prejudicing the interests of parties in the litigation. So if you combine the two arguments, even though ordinarily you wait until the person is making a statement and you think the statement is going to prejudice the interests of parties, then you object. But here, I'm saying that the very language of the motion, already prejudices what it is saying we should do. What it is saying we should do, apart from offending the Constitution, we say we should not interfere in the work of the judiciary. In moving it, there's no way that he will not say things that will not prejudice the interests of parties in the substantive litigation. Why the hurry? Mr. Speaker, he came here in this House and requested to make a statement on this same matter. We objected, but the Speaker gave him the opportunity, and he made a statement on this same matter. Then somebody has gone to the Supreme Court on this same matter. And once the matter is in the Supreme Court, you come to this House and say this House should also refer it to its Human Rights Committee to make a determination whether human rights are being violated or not. I said that is an exercise of judicial function. This House can't do that. Those are my arguments. And that's why I objected. And I told him privately, I told him at the meeting with the Speaker where the motion was admitted, and the Speaker agreed that, okay, you go, you try to arrest it, let the ruling be given. If the ruling is that he should move it, then he moves it, then we debate it. And then if the conclusion is that we should refer it to the committee, the Human Rights Committee, we refer it to the Human Rights Committee. Mr. Speaker, that is my case.
Thank you very much. I would give the floor to Honorable Minority Leader to respond to the preliminary objection raised by the Majority Leader on the motion under reference.
Thank you, Mr. Speaker. This platform and Chamber of Parliament will always be a place to enrich knowledge and to learn. First of all, Mr. Speaker, in response to the preliminary objection, let me rely on Order 103F of our rules book. Yes, F, 103F. Conditions for admissibility of motion. Condition of admissibility for admissibility of motion. Mr. Speaker, our rules provide, under the said order, quoted supra, a motion shall relate to a definite issue and not be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. Mr. Speaker, this motion has crossed the admissibility stage and has met the threshold of admissibility. Indeed, the Honorable Mahama Yarga raised these matters. This was not the original text that was filed. We interrogated it to ensure that the outcome of this motion and the text thereto will not have any prejudicial effect on any matter in court. So, Mr. Speaker, the first leg of his argument falls flat. In any event, Mr. Speaker, with respect, the Supreme Court's writ is seeking an interpretation of the Constitution. The substance of the motion before you, Mr. Speaker, is not seeking a declaratory relief. My law in the minimum is not rusted. My law in the minimum, I kept quiet for you. Learned majority leader. Please.
Oh.
You have not heard me. Mr. Speaker, these things must stop.
Majority leader.
I never said that. He is not paying attention. I'm saying that this motion.
Minority leader, I may be called upon to give a ruling, so I need to understand very clearly. So the fact that the subject matter being a letter written by the Chief of Staff terminating appointment as quoted in the motion is actually before the Supreme Court for the determination of constitutionality or other words of it. Is that the case?
Mr. Speaker, that is not the matter. Mr. Speaker, if you are delving into issue of admissibility, we have to be careful. The motion has been admitted by the Speaker, and the Speaker considered all facts. Allow my argument to proceed with the greatest respect. My contention, first, is that this motion has met the admissibility threshold in accordance with the rules of this House.
Honorable Minority Leader, I intend not to be arguing
Mr. Speaker,
with
you allowed him
I
to
just want to understand whether
Mr. Speaker, the man argued.
He made an allusion to that
quiet.
particular fact. It may be denied that there is no such case pending before the court. So I humbly want to understand whether a case of that nature is pending. You understand? I'm not delving into issues of admissibility.
He raised this very matter. I am saying that what he's doing is on you. The fact that he talked about a pending matter at the Supreme Court was in the full knowledge of Mr. Speaker. He brought this matter to the attention of Mr. Speaker. This matter was brought to the attention of the Speaker. The clerk to Parliament and I were before the Speaker in his presence, with the majority leader. The issues were brought up, and as a result of the issues of court writs, the text of the motion had to be amended. Mr. Speaker later had to look at the court process and did a further amendment before admitting the motion. We've crossed a line. We've crossed a line. And that is why I referred you to Order 103F. This was not the original motion. The original text was under half-hour motion. I have the original text here. It had to be amended and amended again so that we don't go into the realm of the matters before court. And that is why in my second argument, I was adverting your mind to the fact that this motion is not seeking to have this House make constitutional declarations. This motion is not seeking declaratory reliefs. This motion is not seeking for an interpretation of the supreme laws of the land. It is not. This motion is anchored squarely on good practices and governance matters. Mr. Speaker, do not forget that not long ago, we had a matter pending at this High Court in respect of these matters about the collapse of banks, and the applicants petitioned this House. Mr. Speaker ruled that indeed they are facing some civil, they themselves had filed some applications at the court, they were facing some criminal trials, but the issues they had brought were different in form and in shape and required Parliament inquisition. What is before us is not about a matter before the Supreme Court. There are no such parties of personal interest. Of course, I will respect that. If there were, I will respect that. Somebody is before the court asking for some declaratory reliefs in respect of constitutional provision. That is not where I am. That is not the path I've taken. What is before you is talking about governance. I'm not here to move a motion to demand certain declarations. Mr. Speaker, at Precedent, the understanding was that the majority leader will raise this issue, will respond, and then a pathway would be given for us to proceed. This issue that somebody is rising behind and trying to this thing, it will not work. When we agree in good faith, let's proceed accordingly. That is how I understand the practice in this House. Mr. Speaker, the majority leader is also arguing that this matter, if considered, would affect the rights of certain individuals in court. Whose rights? That is not where we are. That is not where we are. The fact that we are referring to a subject matter and invoking the inquisitorial powers of this House does not mean that because somebody is also asking for the Supreme Court to interpret the Constitution, this House stands estopped. The rule of estoppel is not applicable here. It cannot apply against our regular conduct as enshrined in the Constitution. Mr. Speaker, the argument of sub judice is inapplicable here. The majority leader has expressed his own objections. I respect that. But Mr. Speaker, for the good of this Parliament, we need to proceed to move this motion. There is precedence, and I've cited the precedence at the risk of being repetitive. I shall repeat them. I shall go over and then draw the attention of the chair that we've had instances where Ghanaians were facing criminal trials, Ghanaians were pursuing the state in the civil matters, but again petitioned this very House on aspects that they felt that their rights needed to be protected by the people's representatives. What does the motion say? I will go over. The motion is coming under Order 114 of our rules. Order 114, Mr. Speaker, with respect, provides motion on specific matters of urgent public importance. Mr. Speaker, in his wisdom, within his powers of admissibility, has determined that this motion falls under matters of urgent public importance. Mr. Speaker has again found this motion worthy of admissibility. And then, Mr. Speaker, has allowed this motion to be on our order paper. And this is what the motion reads: that this Honorable House considers the directive by the Chief of Staff, Honorable Julius Debra, in a letter dated 3rd February 2025 with reference number SCRDA85/85/01/A, and refers the matter to a committee of Parliament to inquire and to report to the House, as the directive is inconsistent with good governance practices and has consequences. We are not saying that it is in breach. Please, Mr. Speaker, we are not saying that the action is in breach of the Constitution. We are not saying that the action is in breach of any enactment. We said, and has consequences. Mr. Speaker, the language used has been carefully crafted to move away from any courtroom interference. Mr. Speaker, the issue before you is properly before you. Therefore, it is at the point of inquiry that this House, through its appropriate committee, will now consider all the issues, which issues deal with good governance, and report to this House. When the committee reports, this House will now consider the remits of the report, i.e. the findings and recommendations and all. Then we take a decision. Mr. Speaker, for anybody to say that merely moving the motion to bring this matter before the people's representative will amount to interfering in a court process, Mr. Speaker, will be tantamount to denying us our rights as the people's representatives from considering governance issues. Mr. Speaker, our hands therefore will be tied, that this House cannot proceed, and any busybody will then use courts to arrest this House. Because as soon as the matter is raised, you say, oh, I have filed a writ. Oh, there's something before the court. Then, Mr. Speaker, how will this House function? But I shall conclude, Mr. Speaker, I shall conclude by submitting that, Mr. Speaker, the issue of admissibility that he is raising in his preliminary objection has long been dealt with. Mr. Speaker, the entire argument that he forcefully put across, if you listen to him carefully, all his argument has to do with admissibility. But, Mr. Speaker, we've long passed that stage. We have long passed that stage. All that he said, that it will prejudice the outcome of a case, there's a matter before court. Mr. Speaker, the law that we operate with in this House, 103, is clear. That before the motion is even considered, it says the conditions for admissibility of motion. So if you don't meet the threshold, you don't get to this level. All that he's saying, as if the motion is now being filed at the clerk's office, as if Mr. Speaker is consulting us for our opinion before admissibility. No! We've gone beyond that. He cannot. It's too late in the day for him to attempt to invite this House on issue of admissibility, unless he wants to challenge the decision of the Speaker for admitting this motion. Mr. Speaker, we cannot allow this argument to stand when there's already a decision taken. Again, for the avoidance of doubt, I will repeat, Order 103F. A motion shall relate to a definite issue and not be the subject matter of an action on which a judicial decision is pending. So that argument he raised, it was a conditioned precedent that we should meet that threshold. We've crossed that threshold. We've crossed. He cannot now raise a preliminary objection on the ground that there's a judicial matter pending. We've moved past there. In the opinion of the Speaker, prejudice the interest of parties to the action. Mr. Speaker has determined this matter, that the outcome of this motion, the motion in its form and shape, will not prejudice the outcome of any case. The very case he's referring to, he brought it to the attention of the Speaker. The Speaker has determined it, that there's no way what is before us would sin against Order 103F. So, Mr. Speaker, he cannot. He is stopped by the decision of the Speaker under Order 103F. If, however, he seeks to challenge the Speaker's discretion on admissibility, he, as the leader of this House, knows what to do.
Honorable Majority Leader, I am being called upon to make a ruling on this matter. I would Honorable members, I will want to plead with you to suspend the House for 10 minutes to enable me come and deliver my ruling there and then, but not to defer the ruling. So, honorable members, bear with me. In 10 minutes, the House is accordingly suspended for 10 minutes. Was scheduled to be moved. Just about when the motion was about to be moved by the Deputy Minority Leader in the person of Alexander Afenyo-Markins, the Deputy Minority Leader, the Minority Leader, Alexander Afenyo-Markins, the Honorable Majority Leader raised an objection against the moving of the private member's motion, numbered 16, at page 6 of today's order paper. Honorable members, the objection was to the effect that the motion should not be moved at all, that moving the motion will prejudice the interests of the parties in court in a case entitled Henry Nana Boachi versus the Attorney General, suit number J1/12/2025. Honorable members, the motion in question was duly admitted by the Speaker and accordingly programmed to be taken today. Honorable members, the criteria for admitting motions in the House are very clear, and the conditions for admitting motions are provided in Standing Order 103 of this House. I am quite certain that as at the time of filing the motion, the conditions spelled out in Order 103, above quoted, were duly met. However, when the motion was moved, when the motion was about to be moved, there was a preliminary objection, and the attention of the House has been drawn to a lawsuit pending before the Supreme Court, as mentioned above. This action is challenging the constitutionality of the action of the Chief of Staff, seeking for declaration and prohibition, among others, directed at the heads of government institutions to refrain from proceeding with the directive of the Chief of Staff. Honorable members, I have perused the writ, and 9 reliefs were sought. Honorable members, given our constitutional and procedural arrangement, permitting the motion and subsequent debate on the matter in question, or constituting or mandating a committee of this House to do inquiry into the same matter would be a direct violation of our own standing order, particularly Standing Order 103F. For the avoidance of doubt, let me quote the order. A motion shall relate to a definite issue and not be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. Honourable members, Order 123.1 further provides as follows. A member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way as may, in the opinion of the person presiding, prejudice the interests of the parties to the action. Honourable members, I am of the considered view that the motion and subsequent debate on the motion may lead to comments that are sub judice. Honourable members, in line with the stated orders, it is my considered opinion that the matter is sub judice. Thus, permitting any deliberation on same and formation of a committee to inquire into the said matter would prejudice the interests of the parties to the action. I rely on the decision of the Right Honourable Speaker of this August House, dated 6th January 2014, and mentioned in the submission of the Honourable Minority Leader. Indeed, quote, indeed, I am yet to come across a situation in which both Parliament and the judiciary are inquiring into the same matter simultaneously. Honourable members, what will be the effect if an investigation undertaken by Parliament, as anticipated under the present motion, arrive at an outcome and a decision contrary to the outcome and decision of the court. It is therefore my ruling that a discussion of the motion will prejudice the parties to various cases tentatively pending before the court. Honourable members, this ruling has to do with the acquisition of a merchant bank. And the ruling above quoted can be seen in the official reports, 4th series, volume 85, number 1, column 36. It is also worthy of note that in the same official report, the Speaker then made reference to Right Honourable Peter Alajete in a ruling alluded to the sub judice rules when he said, quote, the Speaker may, in a particular case where it is quite obvious, refuse to admit a motion, especially when it is covered by a clear-cut case. For example, if you put forward a motion affecting a matter which is pending in court directly, and it was brought to the knowledge of Mr. Speaker is bound to draw attention to the fact that such a motion cannot be properly debated by the House, cannot be accepted. But it does not allow, it does not follow that in every case which a motion is accepted and listed, the Speaker has necessarily gone through the motions of deciding every issue of propriety involved in that motion. Honourable members, regarding the motion at hand, I am reliably informed that at the time the Right Honourable Speaker admitted the motion, the fact of an action pending at the Supreme Court regarding the subject matter was not brought to his attention. Based on the above precedents, the House must stay its hand off the motion and allow other organs of state properly mandated under the 1992 Constitution of the Republic of Ghana, thus the judiciary, to deal with the matter. Accordingly, the motion and the subsequent debate on it is stayed pending the determination of the matter by the Supreme Court. Honourable members, accordingly, the objection is sustained. The motion, therefore, cannot be moved. I so ruled. Yes, Honourable Minority Leader.
Mr. Speaker.
Minority Leader. He's on his feet.
Mr. Speaker, my first duty as a legislator is to thank you as the presiding officer in matters of such nature. However, I may disagree with you. I've always held this view since I entered this chamber in January 2013, that matters would always resurface. As a practitioner in our court, I've had low moments where cases that I believed in strongly that I could win, I ended up losing sometimes 7-0, 6-1, 5-2. But after some 360-degree turnaround, said dissenting views expressed carried the force of law in future decisions. I disagree with you, but I'm not sad. Mr. Speaker, however, we are dealing with matters of integrity, and I would take the liberty of this opportunity given me by you to correct some aspect of some pronouncement you've made. Mr. Speaker, and I say so believing that the majority leader, who has so much respect, has so far demonstrated integrity in his dealings with me. I also believe that the clerk to Parliament has been such a man of integrity. Mr. Speaker, you said that you are reliably informed that at the time the Speaker admitted this motion, he was not in the know of the pendency of the suit. Mr. Speaker, with the greatest respect, I won't challenge your ruling, but let the records reflect that that aspect of your ruling, which is already printed, which you just read, is not the case. The majority leader, in the presence of the clerk, my good self, brought the matter up that there is a Supreme Court decision, writ. In fact, he brought it to the attention of Mr. Speaker. Mr. Speaker subsequently requested for the motion to be amended. We all worked on it. In leadership, we all worked on it. Mr. Speaker, in the presence of the Right Honorable Speaker, we worked on this motion. Subsequently, Mr. Speaker said that because of the pendency of the suit, he further amended the motion. So if you are, in your view, this admissibility criteria, you said in your ruling that although the presiding officer may admit, it doesn't mean that he has considered the entire propriety. It's good. Look, Parliament of Ghana will not end today. So I am fine. But Mr. Speaker, don't let it be part of your already prepared ruling. That, because when the camera showed that the thing has been typed, printed, let me finish, Ayarga. These are matters of integrity. I need to finish. When I'm done, you will make your point. If indeed,
Honorable Minority Leader, with all due respect, let me recognize Majority Leader.
I didn't get what you said.
Let me recognize the Majority Leader. I recognize the Majority Leader.
Well, that's fine.
That Honorable Majority Leader, before you come in,
Yes.
I think it is tried learning
Yes.
that if a ruling is delivered by the Speaker, anybody who wants to challenge the ruling knows what to do.
Mr. Speaker.
So a situation where
Mr. Speaker,
I make
you are
reference,
prejudicing. I'm not telling you. I'm not challenging your ruling.
But Minority Leader, if you listen to the ruling carefully, I make reference to the decision in the merchant case, in which Right Honorable Speaker Alajete was quoted, and I proceeded to read Honorable Alajete's ruling. So, Right Honorable Minority Leader, with all due respect, where I sit, I disagree with certain things that you said, but I will not be dragged into the debate. Honorable Majority Leader.
Mr. Speaker, the Minority Leader knows that if he disagrees with you, Yesterday you were happy. Yesterday you were happy. Yesterday you were happy. The speaker ruled in your favor. Yesterday you were happy. Some days you lose, some days you win. What's your problem? Some days you lose, some days you win. Oh, no, but that's the issue. That's the issue. The issue is that no matter how you disagree with the speaker, don't impute improper motives. No, when you say you're already written, you are imputing improper motives. You are saying that he wrote his ruling even before coming here today, because he asked for 5 minutes, he came back. Don't forget that the matter was referred to him and it was already in the order paper. And like I told you last week, I also told him that you will move the motion, I will object, he should prepare to write a ruling. I told him, I didn't hide it. No, listen, I didn't hide it. Even in my argument, I repeated it. I'm saying that in my argument, I repeated it. I didn't hide. In my argument, I repeated it. When I was arguing, I stated it clearly that since last week, I indicated my objection and it was agreed that the matter should be resolved on the floor of the House. Mr. Speaker, let me indicate that on the question of on the subject matter, but I didn't have a copy of the writ. At that time, I didn't even know what were the specific reliefs sought. It was yesterday that I then went and researched and then saw the writ, saw the reliefs, and printed a copy and brought it. So please, it is the case that I mentioned it to Speaker that somebody had gone to court, but I didn't have the specifics of the case. And he said, you should go and see what you could do about it in a way that doesn't offend the arguments that I raised. And you went and you were struggling to amend it. And I told you that there's no way you will amend it and succeed in curing the defects of the motion. I told you. The clerk was there. I told him that there's no way because the matter is in court. So please, if you want to litigate it, you can come by motion. If you come by motion, we can debate it again, and then a decision will be taken. But for now, it's ruled. It's already, past 7. Members are tired. Some of us are fasting and all that. So, Mr. Speaker, we are in your hands. You can adjourn so that we can reconvene on Friday and continue business.
Well, honourable members, I think matters relating to the motion numbered 16 regarding the ruling is foreclosed. So, Honourable Minority Leader, conclude.
Mr. Speaker, with the greatest respect to you, and in fact, to the Majority Leader, and to the Clerk of this House, I wouldn't want to bring him into these matters because he wouldn't have an opportunity to argue his case. So I will leave him out of it. But Mr. Speaker, let's be very factual. In our account of matters that come to our attention. Mr. Speaker, you have indicated clearly, without any ambiguity, without any equivocation, that you are reliably informed that at the time this motion was admitted, Mr. Speaker had no knowledge of the pendency of the writ. Mr. Speaker, With the greatest respect. This is where I want us to address the issues of integrity. Because, Mr. Speaker, whatever it is you've ruled, but I want us to be on a path that tomorrow we will all be properly guided and guided well. Mr. Speaker, I sit here, today is Ash Wednesday, I'm a Catholic. Today began our Lent, we also started our fasting today. I am a Catholic, today is Ash Wednesday, our Lent began today. I will not, for the sake of politics, rise on my feet and dishonor that which I believe in so well, my faith as a Catholic. I will not dishonor it, particularly on an occasion like this. Mr. Speaker, we did discuss the writ. The Speaker, the Right Honorable Speaker, was made aware. In fact, Mr. Speaker, I would avoid bringing the clerk in because there was back and forth on the text, all in an attempt not to be in conflict with the matter in court. We arrived at this as a safe text to proceed. Having said that, I shall conclude by, Mr. Speaker, saying, still on the issue of integrity, the majority leader says that because he brought this matter to your attention and he's been informing you that prepare, I will not cast aspersions at you. Never. I won't do that. I will never do that. But, Mr. Speaker, I was watching when you were reading your ruling. I was watching from the screens, the paper you were flipping. I found it, in all humility, at the risk of sounding immodest, I found it curious that you took leave of us for 10 minutes and each page you turned, printed, typed, was voluminous. But if he says that he had already informed you and you were in the know and you are therefore prepared your written ruling even ahead of listening to us, so be it.
But
Mr. Speaker,
before you come
Mr.
in,
Speaker, before.
but Honorable Minority Leader, you've also equally informed me about your motions, and we had some extensive discussions about it. Is that not a fact? So,
Mr. Speaker, I'm surprised that he will be saying the things that he's saying. Because, Mr. Speaker, the argument that we engaged in before the Speaker himself, you should have been there. In the end, the Speaker himself said, okay, I cannot stop you people, so you go and prepare your motion. You go and prepare your objection. And when we meet in the chamber, when he moves, you object, I'll allow you to state your various arguments, and then I will rule. This was since last week. Even the Speaker knew that today, if you move the motion, I was going to object. And then he will rule. So if he's asked you to come and then handle the matter, definitely he would have given you instructions. And you wanted him to wait and then defer the matter to next week and give a ruling? No. He has to prepare because he's been told. Same way you were told. I told you since last week that I will object. I didn't hide. So why are you creating the impression that there was something that, untoward happened between myself and then the first deputy speaker? Even in front of the speaker, I told him that I will object. I said, I will not allow this to happen. You can't have a matter in the Supreme Court and then you want the same matter to be litigated in the Parliament. I said, it's not proper. It's not tidy. You are going to put us in direct conflict with the judiciary. And this is not right. I told you. You insisted. You came up with a coinage that is a governance issue. I said, there's no way you will structure it in such a way that it won't be a constitutional matter. Take the motion. Please, take the motion. In the end, in the motion, you cite the Constitution. You say that that matter is against Chapter 5 and Chapter 6 of the Constitution. And I said that is where you will end. To say that it is a governance matter, you indirectly are saying that there is a violation of the Constitution. And whatever committee you refer the matter to will have to look into whether or not the conduct violates the Constitution in order to arrive at a conclusion. And I argued extensively that that is a judicial function. And the judiciary is already seized with the matter. So don't push us into a conflict with the judiciary. This is so straightforward. And when the speaker concluded that, okay, go and amend it whichever way you want with the clerk, and I told you, there's no way, there's no amendment that will save you. In the end, this is what you did. You invited me to participate. I said, I won't participate. I won't participate because I don't know of any coinage that will save the motion. Mr. Speaker, please conclude. I don't like the way that you are trying to create an impression that there was some, untoward thing or conspiracy between the first deputy speaker and then myself or any other person, because this is a matter that you were given notice that it will happen this way.
Honourable members, I stand on Order 56-2 and adjourn the House to Friday, 7th March 2025 at 10 o'clock in the forenoon.